Yeah,
You can't say anything else on.
that's when I had originally said it, and they told me I could said it that day. I still had it down on my calendar. I had it on both.
Apparently, Judge Wallace has advised he cannot say anything else on that day.
Okay.
You need another date?
We do need another date just to set it in case we can't agree, but I think we'll probably be able to reach an agreement on it.
I don't think Ms. Roberts is available in August, the dates that we have.
On the August dates, those are double dates, and I've already got everything set.
September 3rd.
You also have a Jones versus Jones case that's next, and you have a motion to continue in that.
I do.
Yes. And our only issue, and I don't know if Your Honor reviewed the motion, is the mental health of the minor children. It'd be the only reason that we would need to
What's your
press
reason? I
forward.
haven't looked at the file yet. What's your reason for a continuance in that case?
Well, there was two reasons. Number one, inappropriate notice. We got it on Tuesday. Under the rules of civil procedure, we're entitled to 5 days notice, 5 working days notice. We were not provided 5 working days notice. I got it at 5:03, emailed to me. And again, just getting ready for it. Ms. Duke has made some accusations that are going to take this will be an all-day hearing.
If I may briefly respond, it was sent by certificate of service on the 18th, and so we complied with the rules of civil procedure, and then I also emailed it at 2:00 on the 23rd.
So
So what
emailed
are
3 days.
your issues regarding the urgency of it, Ms. Duke, in the Jones case?
A few of the minor children are going to have to be in significant therapy based on the continued threats of the father and the bad mouthing of the mother and some things that he's doing to try to manipulate the children.
And that's
The
contested.
children are here if Your Honor needs to hear from them.
And again, the second reason is I had a deposition scheduled with Ms. Duke's law partner at 11:00, but late Friday afternoon, Mr. Vandervoort filed a motion to continue, and we heard that in front of Judge Turnbow, and he granted the continuance. So that was the other reason for the continuance in my motion, but that resolved itself. But it did lead to the fact that I got this and had no time for preparation, and so we just need to continue.
What about, the 9th of July?
The 9th of July, I have Judge Lockhart Mashes in Dixon, and I have
I'm
Carbone
thinking
versus
is give you
Carbone.
a date for both of these that you may
Bugle.
have to hear it out of county because someone else will be here in July.
Judge, may I approach off of the video?
Mute this, please.
I don't like for everybody to know that I'm going out of town from the 5th through the 12th of July.
That was the reason we were moving Butler.
Yes.
18th.
18th of July.
This is all contingent upon your agreeing to hear it out of county because I'm going to be in Cheatham County, but I have that date available. And other than that, I could give you
As far as I know, I try to keep Fridays
the
open.
29th.
The 29th, again, that's Judge Lockhart Mashes, Dixon Chancery, and I have a Bradford versus Bradford, and then a final hearing in a Crispin
I'd
versus.
rather hear this one on the 31st than this bump to the Bates case.
Now, I can do the 18th. I don't know. That one's different.
I have a matter that the Hickman County Court set, but I will file a motion to continue on that one. So I can do July the 18th. It's important that this be heard.
And we're doing Butler mediation on the 16th of July. So hopefully we can get a date on it. We'll just work together to get a date on it after the mediation.
All right, so at this point, we're gonna set the Jones case that Ms. Roberts is asking for a continuance on the 18th of July.
Yes, and can we admonish both of the parties to verify that nothing is to be said about this? That is our major issue. The kids are calling and crying, and we would assert that we've got text messages to back up everything that's been said in our motion.
I'm not gonna assume the facts in the case. Are the parents here, both sides?
They are.
Bring them up. Mr. and Ms. Jones, we're moving heaven and earth to get you a date to hear this motion that's been brought up, and there's been allegations that have been made by both sides about the situation. What I'm not assuming that any of those facts are true, but what I'm going to tell you is this: I'm putting an order down today that you two are not to discuss this case with the minor children. Period. You know, if the quote, is there a guardian ad litem in this case?
I think we need one at this point, Judge.
I'm not opposed. I don't know that there's funds available to do it. It's a private case, but if we're never opposed to one, that's fine. We would just ask that both parties be ordered to make a deposit with that guardian ad litem up front.
Well, the reason the guardian ad litem is even being discussed is because of the fact that you've got minor children in the middle of this. You both may be fine people. You both may be good parents in your mind, and that's good. But my main concern and the main issue that I have in this case is to protect the best interest of the minor children. So if that causes me to have to come down hard on one of the two of you, so be it, because my interest is trying to protect the children. But by the same token, children are very perceptive and empathetic to their parents. And if they see one of their parents upset about something, then they naturally will, try to side with that parent, and they will naturally try to empathize with that parent. So let's try to shield the children from whatever's going on between the two of you. Let's don't involve the children. And I say it in a very nice way, but I'm telling you, I'm ordering you not to involve these children and not to have the children influenced, not to discuss this case with you about this. If they have questions about it, you just tell them, honey, I can't discuss it with you because that mean old judge told me he put me in jail. You don't have to say it like that, but that's exactly what will happen. If I find out that you two have broken my order, then I'm going to put you in jail, because I fully and firmly believe it is in the best interest of your children not to be put in the middle of this situation. Children are, used to having both parents. That's the home environment they had, and now that's blown up. Why wouldn't they be upset? I mean, that's a natural reaction to the fact that what they thought was their cocoon of protection and the home that they had is now no longer there, because their parents can't get along and they're going to go through a divorce. But under the circumstances, you two can still make it okay for your children by protecting them from being exposed to all of the negativity that a divorce naturally brings about. Allegations may be made. Those allegations would have to be proven in court. I understand that children may be called to testify. I think that's a very regrettable, but sometimes a very necessary step to be taken. But that's the reason that I'm considering a guardian ad litem being appointed, is the fact that the children need somebody to advocate on their behalf. Now, Mickey Furlong Smith is the one that I generally use in a lot of cases. I would simply suggest, since I've set this hearing for the 18th, that you two need to check with her and make sure she's available. Before, I know she's out of town
She's
right
in
now.
Chicago right now.
So it would be my opinion that you need to check with her and see if she's available on the 18th. If not, we need to get somebody else that is available.
Yes, sir.
And there are other individuals who can do that. Lynn Coffinberry is another one that we use on a regular basis. But let's find a guardian ad litem that's available on the 18th so that we can do this.
Yes, sir.
Where are we going to hear this? Which courthouse?
Courtroom 5 in the Justice Center,
In Dix, okay.
Charlotte, Tennessee.
You just said you were in Cheatham, but where you're going to be in Dix.
Right.
And again, some guidance, Your Honor. Again, as you are well aware, children and their electronics this day are something that I didn't necessarily grow up with, but punishment issues when you're taking electronics away from children because of misbehavior, whatever, does that include cell phones? And then escalates into, oh, you've taken my cell phone away from me.
My client doesn't have a problem with that at all.
So again,
But if she's explained to the children, if you've done something, Dad can take phone away. Yeah, absolutely.
Put it in the court order that one of the avenues of punishment. How old are these children?
they range.
We've got 16 and 11 right now.
Well,
There's a set of twins.
I'm of the opinion that if they are misbehaving and there's some reason to do that, taking their cell phones away is better than having a leather belt across the rear end like my father used to do with me. So I think that would be certainly permissible, and the children need to understand that that is not an abusive exercise the parental authority.
And go call the other one on somebody else's cell phone and say, somebody took my cell phone away and I'm
Let's
in
just put it into
abuse.
court order that the court authorizes both parents to take the children's phones away if in an appropriate situation as parental discipline.
I will assert with the court that my client has absolutely no problem with that, but it was discovered that one of the children was confiding what was going on in dad's home, and that's when the child's phone was taken away.
And that is highly disputed when and again, that's what they want you to believe, Judge. And I know you're not listening to that, and that's why I ask in a generic sense. I'm not trying to prime the pump that Ms. Duke is trying to do. It's disputed.
You two are good lawyers, but you are kind of like oil and water. And under the
Good
circumstances,
and bad. I realize that, Judge.
it is yin and yang, is that what you said? And there is some truth to that, whether you like it or not. But under the circumstances, I'm not assuming any of those facts are true. I'm trying to give you an opportunity to be heard where we can establish what the facts are. So let's just try to maintain the status quo and keep the children protected to the best of our ability until we have that hearing. All right. Thank you.
Thank you.
Thank you, Judge.
Good morning. You are Jackie Lynette Holland.
Yes, sir.
Raise your right hand, let's place your under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case will be the truth, the whole truth, and nothing but the truth to help you God?
You, Ms. Holland, you have filed a request for a divorce, and there's some issues with the complaint that you have filed because on the second page of your complaint, there is a provision under paragraph 7 that states, orders of protection and other orders, check the box that is true to you. And the first box that was checked is there is no order of protection. And then down below that was checked there and initialed, yes, there is an order of protection now in this court. It will stay in effect until the divorce judge changes it.
Okay, there's not an actual order of protection. There was an order attached to domestic violence, a no contact order attached, but not an actual order of protection.
Right. And there is no restraining order other than the statutory injunction. Is that correct?
Correct.
So your complaint contains certain statistical information. Is that information true and correct?
Yes, sir.
You've also filed with the court a marital dissolution agreement. That marital dissolution agreement purports to bear your signature and that of your husband's. Is that your signature?
Yes, sir.
Is that your husband's signature?
Yes, sir.
Do you believe that agreement fairly and equitably divides all your property and distributes all of your debts? You have provided me with a final decree. I need just a moment to look it over. An order of protection is not is a peculiar matter that is before the court under a specific statute. What you're talking about are bond conditions in a criminal case. Change that to indicate there's neither party has a current protective order, but bond conditions apply. Besides your final decree, you can get a copy of it a little later in the morning, and you need to mail a copy of that to your now ex-husband. Thank you.
Twenty 2025 CV 64, James Johnson.
Morning, Mr. Johnson. Raise your right hand. Let's place you under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
You are James Glenn Johnson.
Yes,
Mr. Johnson, you've asked to change your name, and I need to ask you some statutorily required questions. Are you asking to change your name to avoid your just debts or creditors?
yes,
Are you asking to change your name to avoid criminal prosecution?
yes,
You have stated the reasons why you want to change your name to William Glenn Stevens Johnson. And is that reason the reason that you're asking to change your name?
William Glenn Stevens was my birth name, and I'm asking to reclaim that.
Okay. So do you want your new name to be William Glenn Stevens Johnson?
Yes.
All right.
And I attached the Johnson because I've got two signs, successive race.
I understand.
Yes.
I'm going to ask you, if you will, to sign the order where it shows that you've approved that And you signed the new name as well. So, I'm granting your name change, but you'll need to sign, approve that where the X is there,
So,
with your new name. William Stevens Glenn Johnson. William Glenn Stevens Johnson. All right, Mr. Johnson, I have granted your name change and signed your order. You can get a copy of it a little later in the morning once we've transmitted it over to the clerk's office, okay? All right, thank you.
2025 CV 69 regarding Kylie Ottenreed.
Good morning. Anyone who's going to testify, raise your right hand and be placed under oath.
Do you solemnly swear or affirm that the testimony you shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, this is a petition to change the name of a minor child. Is that correct?
Correct.
And you are the minor child. Don't look that minor to me. How old are you? 17. Okay, are you consenting to this name change? Right. And who is the biological mother? You've all been placed under oath. Do you testify that you're asking to change the name of your daughter to avoid any criminal prosecution or to avoid any payment of debts?
No.
Right. My understanding is that the last name is Alton, is that correct?
Ottenreid.
That she was given that name at birth, but that's not the biological father's name. Is that correct? Right. And we're asking to change it to Kylie Nicole Elam. All right. And Ms. Elam, you are in agreement with that change, is that correct? And of course, the Wesley Alton Reed has signed off on the agreement as well. So, all right, I will be glad to change your name. I always make that offer that I can change your name to anything you want it to be. If you want it to be Beyonce Elam or Taylor Swift Elam or anything like that. So you're happy with Kylie Nicole?
Yes.
You submitted an order signed off on by both Wesley Alton Reed and your mother, so I've signed your order. You can get a copy of it from the clerk.
Thank you.
Thank you. Thank you.
2025 CV 68 Madeline Forrester versus Timothy Whitfield.
I represent Mr. Whitfield. We're ready for a hearing.
All right, I mean,
He's gonna call the rest of the document.
Ms. Forrester, this is here today on an order of protection and a hearing to determine whether or not the order of protection should be issued for a longer period. There was an ex parte order of protection that was issued back on June the 2nd, and this hearing is designed to determine whether or not you want to have that order of protection extended for a longer period. Do you wish to have that extended?
Yes, sir.
All right, then we'll have to have a hearing. You have the right to an attorney to represent you since Mr. Whitfield is represented by counsel. Do you wish to hire a lawyer?
I'll hire one, yes, sir.
All right. Are you asking for this matter to be reset for you to hire a lawyer?
Yes, sir.
Ms. Roberts, she's asking to hire a lawyer, and I think it's probably in her right to do so. When's the next chancery date after the vote?
Well, Your Honor, I'm not aware of any statute that grants her the right to extend the order of protection past the 15 days that it's done. So understanding that if she wants to hire an attorney, then we are not agreeing for the extension of the ex parte order of protection.
The ex parte order of protection is extended by statute for 15 days from the date of issuance, unless it's extended further. To extend it further, we would have to have a hearing, and that hearing would require testimony to be taken from you and from Mr. Whitfield. And under those circumstances, then you are putting yourself at the issue of that. Resetting it means that this order that was issued ex parte would be expired by statute, but that you would still have the right to come back in on the next day I give you and to have a hearing to determine whether an order of protection should issue. Do you understand that?
Yes, sir.
And that would give you an opportunity to consult with an attorney and determine whether or not that should or should not be done.
Yes, sir.
And when's the next first available date?
So the lapse will be on the 15th, the 5th of July, Your Honor. The parties have a minor child. So
So the first thing after the 5th is July 7th.
Let me see.
we have just taken Butler off July 7th. I've got to be here.
You have,
Well, in the morning, I do. I have a Brighton, James, and a Harvey matter. That are
right,
short.
we'll set it for July the 7th in front of Judge Wallace. You need to consult with an attorney as quickly as possible and have your attorney contact Ms. Roberts. Perhaps the two of you can arrive at, through your lawyers, can arrive at some sort of an agreement. Okay.
Ms.
Yes,
Shaw,
sir.
I have a petition to establish paternity that will be served on her.
All right.
That is
And
out.
another reason you need to go ahead and hire yourself a lawyer as soon as possible.
Yes, sir.
All right. July 7th.
Yes, sir. Thank you.
This is here on pro se petition for an order of protection. And we have received a call. The clerk's office has received a call from Mr. Johns, and he's indicated he could not come today and was advised that the case would probably be dismissed and he'd be taxed with a court cost if he didn't appear. Is Calvin Jones here? Clerk says that he sounded pretty high when he called, so I'm going to dismiss this case. He's taxed with a court cost. You are, I assume, not in jail over an order of protection. It's
No,
something
I'm
else.
okay.
All right. Case is dismissed. Thank you.
Is my daughter. She is here. If you would like to speak with her.
It's not a question of whether I would like, I'm just interrupting you and I apologize. This is not a question of whether I want to or I would like to speak to your daughter. This is your case for you to try. You have brought a petition for order of protection and you have the right to call witnesses according to that petition.
Yes.
It is up to you to prove the allegations in your petition, and you can do that by calling witnesses and testifying yourself. But Mr. Holly represents the defendant in the case, and he will be able to also call witnesses and cross-examine anyone who testifies. So if you have your daughter, how old is your daughter?
10.
You have a 10-year-old child here that you're going to put on the witness stand?
No, sir, Your Honor. I was told by the clerk's office that to bring her in case you wanted to speak to her in your chambers. And that if Mr. Holly or Mr. Story objected, that then she would have to be brought in here.
Well, number one, as I said, maybe the clerk was simply trying to say that if she's a witness, then she needs to come and that's the method by which she would be able to testify. It's not a question of whether I want to hear from her. Question, unlike some other instances, this is I cannot take sides. I can't try your case for you. I have to let you put on your proof and let you testify. Then Mr. Holly can cross-examine you. Then if you want to call your 10-year-old daughter, then you have the right to do so. But the only method would be if they object to hearing from her in chambers, then it would have to be done in open court. And then Mr. Holly can put on any proof he wishes to, and then we'll go from there. But at this point, obviously, I'm not going to be calling your daughter to testify. It will be up to you to make that decision. Let's, first of all, this is the last case, is that correct? All right, then are you ready to proceed on your petition for order of protection?
Yes, sir. I was also advised by the detective who, I've been told by both detectives that were involved in this case that I needed to get an order of protection for my daughter. But I was also told that I really didn't need to discuss the case because it could interfere with the investigation. So I'm kind of at a loss as to what I can and
Do
can't
you
say.
and Mr. Story, are you married at the present time?
No.
Is there an order down regarding custody and visitation in a chancery court somewhere?
Yes.
That in this court?
No, sir.
Where is it?
That is in Hickman, and I went to the Hickman County Court first and was told that because the incident occurred here and because there was already an open investigation here, that it needed to be heard in this court.
But, well, the only thing I can tell you is that if the basis for an order of protection is the fact that there are allegations made against Mr. Story regarding his conduct toward your daughter, then those allegations are going to have to be proven in court. And the only way to do that is to talk about the case if it's under investigation or not. Otherwise, you can choose to not pursue this order of protection and go back to, and consult an attorney and file something in the court where the custody order was down to try to get something addressed in that court rather than this court. But even then, the allegation would have to still nonetheless be discussed in order for a judge to make any sort of modification of the prior order. So it can't just be that, oh, allegations are made and now we're going to change everything regarding a custody order. You have to be able to put those facts in the record, and they have to be tested by cross-examination, and then they would have the opportunity to take the stand and to testify themselves. If Mr. Story wants to take the stand in this hearing and put himself subject to cross-examination by you regarding these allegations, then anything he says can be used against him in the prosecution for the criminal case. And he would have to be advised of that fact before he testifies if there's a pending criminal investigation. What I'm going to do is I'm going to take a recess, and I would suggest that you might contact the officers that are involved in this investigation and tell them what's about to happen. I'm going to read through the file, and then when I come back, we'll take a recess for about 15 minutes and give you an opportunity to consult with those officers and determine whether or not you want to proceed with this proceeding or not. If we do, then we'll come back and we'll have a hearing, and I'll make such a ruling as I think is appropriate. But at this point, I'm going to read through the file, and we'll give you an opportunity to consult with the state, with the district attorney's office, or with the officers.
Okay.
We'll stand in recess for 15 minutes.
Can I just report briefly, Judge? I've got the final decree. I've got some prior orders of protection that were unsuccessful. Hickman County Court wants to see those for your review.
I'm going to look at this file and this file only until we get into a hearing. You can then introduce whatever you want to.
Yes, sir.
All rise.